Good evening, those in the room and those online. My name is Geoffrey. This event is about wars. More particularly, it's about whether and how law, lawyers, and judges may reduce the number of wars which we, but more particularly you, the students, may encounter in your years to come. Our two speakers tonight are, first, Dame Rosalyn Higgins. An outstanding career as an academic, as a lawyer, led to her becoming, in 1995, a judge at the International Court of Justice, the UN's court in The Hague. It doesn't deal specifically with crimes and criminals, but it does deal with crime when it deals with breaches of conventions and treaties by states, and most notably, it may be thought, when it comes to the issue of genocide. Dame Rosalyn became the presiding judge of that court, and so, in the vernacular of the printed press, she was top judge in the world's top court. Sir Adrian Fulford had an outstanding career at the bar doing criminal cases before he became a High Court judge on becoming a judge of the International Criminal Court, the only world court that deals with war crimes specifically, although its jurisdiction is not universal, it's partial. And he ended that and became a judge of the Court of Appeal of England and Wales. So to match Dame Rosalyn, Sir Adrian is a top judge from the world's top criminal court. Each speaker will have about 10 minutes to kick off, and then 5 to 7 minutes to comment on each other's contributions. After that, we will be joined briefly online by Yuriy Belousov from Kiev in Ukraine. He is in charge of prosecutions of war crimes in Ukraine. He has on his docket a modest 110,000 potential war crimes cases that are being investigated. And with such success before the termination of that war, it may be that Ukraine will have to think imaginatively about how it wants to deal with accountability processes, maybe moving beyond the standard methods of dealing with war crimes currently planned for that country. So I'll ask him for about 5 minutes to say what, if anything, he wants to, and maybe to comment on what the speakers have said. We then turn to question and answers with the protocol of these events, which is that you are allowed 30 seconds, and no more. In that 30 seconds, don't introduce yourself. We're not that interested in who you are. We only want to know what you think and have to say. Please don't thank the speakers. We'll do that at the end. And still less embarrass yourself by seeking to compliment them on their contributions. In light of who they are, you might think that would be mildly impertinent. So when we come to question and answers, there will be priority given in the beginning to 30-second contributions from students in the room. And then questions and answers will be thrown open to everyone else, here and online. It is essential that we recognize in Q&A that we're not here to say anything one way or another. It's up to the speakers to say differently. But so far as you're concerned, nothing one way or another in support of or against either side in either of the two wars, Russia-Ukraine or Israel-Gaza, that will be concerning us. Not only is it not the subject of this evening's discussion, but particularly in relation to Israel-Gaza, it's always likely to generate heat, not light, and quite easily can cause offence. So your 30 seconds have to be strictly limited to the topic. If you go beyond it, I'm afraid you'll simply be cut off. What led me to suggest to the committee that organises these events this title? It was, of course, the Russia-Ukraine war. And these possible three premises, which you may or may not agree with, but I've shared them, as they say in the modern terminology, with the two speakers, and they haven't said I can't mention them. The first is that there is no real world order. There are bits of world order. The United Nations has some powers, but as to whether there's a complete world order, no, there isn't. There are, as I've already explained, courts that do have some power to deal with war criminals, but it's a very, very patchy business. It's incomplete. The third and most important of the propositions I've suggested is that there is absolutely no evidence that war crimes trials, even when they do happen, deter the next warmongering leader of a nation from doing what he or she wants to do. Of course, if it's been effective, we won't know about the war, but nevertheless, there's actually no evidence that war crimes trials deter, generally, the next warmongering leaders. And in light of where we are, with two wars, in each of which there has been reference to the use of nuclear weapons, it may be thought that for law, lawyers and judges, perhaps the most important thing for us to focus on now, for our and for your benefits, is how, if at all, law can help in deterring the commission of war. Dame Rosalyn.
Master Nice, thank you very much for that introduction. Master Treasurer, Sir Adrian, colleagues and friends in the audience. I use a split second of my time to apologize for speaking outside of the side of my mouth. I had an argument with a piece of pork crackling and it won. And so I am minus my front tooth, and I hope you will forgive me for that. Now, the title, Peacemaking Ahead, Traditional Methods of Accountability and New Solutions, this title carries with it several different ideas, including notably how to make peace, peacemaking, and issues of accountability for violations of the peace. And I know that underlying this, there's another question that Master Nice would like addressed this evening, hidden within it. How can future wars be deterred? So there is a lot for us to talk about. So I'll begin by saying that international law is to provide an operational system for securing values we all desire, but it's not only about resolving disputes. An efficacious legal system can contain competing interests, which surely will exist, allowing those who hold them not to insist upon immediate and unqualified vindication. Of course, sometimes dispute resolution will be needed, and there are today a huge number of structures serving that purpose. And sometimes, and this is very much in our view at the moment, norms are needed to limit the parameters of conduct where dispute resolution fails, but these last elements are only a small part of the overall picture, though they fill our screens at the moment. We can't totally avoid the topic of what exactly constitutes international law, what international lawyers call the sources of international law. This is a very big topic, but I'll limit myself to saying that the commonly agreed starting point is Article 38 of the Statute of the International Court of Justice, which is appended to the Charter of the UN, and the UN Charter is binding on us all. And Article 38 of that statute refers to international treaties, to international custom as evidence of a general practice accepted as law, to general principles of law, and, subject to certain qualifications, the teachings of leading jurists. Now, to revert to our main title for this evening, the UN Charter itself does have something to say on peacemaking. Articles 36 to 38 deal in some detail with making and keeping the peace. Of course, a huge amount of structure since that time has been built up to implementing those ideas. Peacemaking does not lack for ideas and innovation. To think about how future wars can be deterred, our sub-question, there are specific prohibitions on the use of international force in Article 2.4 of the Charter, as well as in Chapter 7, which covers Articles 39 to 51 being the retained right of self-defense. But conflict does still occur, and a body of law known as Yuriy Belousov will try to mitigate the ensuing horrors. This includes, but is not limited to, the growth of the idea of international criminal courts based on the violation of international criminal laws. And Sir Adrian will no doubt be talking to you about that. So my comments will be on the jus ad bellum, whether the actual recourse to the use of force is legal. And as we'll see, the complex world we live in today all too often does not allow of clear answers. It's useful, I'm afraid it's for me unavoidable, Geoffrey, to refer to the two major conflicts shattering our world today. So far as Russia's invasion of Ukraine is concerned, the applicability of the jus ad bellum, is it lawful at all, is relatively straightforward. All member states of the UN, including Russia and Ukraine, are covered by the provisions of Article 2.4, the prohibition of the use of force against a state, and Article 51 of the Charter. Let me just briefly remind you, Article 2.4 provides that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Clearly claims that independent UN member Ukraine is really ethnically and historically part of Russia, that it's not a real state in spite of its UN membership, that it was about to attack Russia, that it was a puppet in the West in preparation for that attack, are not convincing. And there's also a crucially important principle of international law, namely uti possidetis, which provides in the post-war world that international frontiers may not be changed by force, but only by the agreement of both parties. No more persuasive, legally speaking, is the insistence that the greatest tragedy of the last 70 years was the dissolution of the Soviet Empire, as Putin has frequently said, and that its rebuilding by force is not a claim recognized by international law. Now, the veto in the Security Council has prevented clarity in voting in that body, but in the General Assembly, it's been made clear that the Russian invasion of Ukraine is not to be excused by claims of empire, self-defense, alignment with the West, ethnicity. Article 51 of the Charter retains, in the face of a violation of 2.4, the inherent right of individual and collective self-defense. I do find it curious that many states supporting Ukraine have not invoked this provision, but have allowed the dialogue to drift to one about what NATO, a collective regional defence arrangement allowed under Article 52 of the Charter, may or may not do without itself risking direct hostilities with Russia. I think there's a good article for students to write on Ukraine, Russia, the end of collective self-defense, ? The thinking is that training and arming Ukraine falls the right side of that line, a line irrelevant to collective self-defense. It seems that so far as NATO is concerned, collective self-defense under Article 51 is a dead legal duck. Of course, the accountability is not in terms to be found in the jus ad bellum provisions of the Charter, but there are hints of it. I'll simply mention that last week, you may or may not have noticed this, the Russian judge at the International Court of Justice, a very nice man who I think has behaved with great dignity throughout the last couple of years, sought to be re-elected to the International Court of Justice. And since World War II, there has always been a Russian judge on that bench. Election to the court requires a majority of votes in both the Security Council and the General Assembly. He could not muster a majority in either. And in the General Assembly, contrary to the views that were being argued by Putin, that this was all an alliance of the West against the Third World, the Russian judge secured only 77 votes, the second lowest votes in that body in history. And he has not been re-elected. He's been replaced not by a Western judge, but by a respected competitor from Romania. Now, to turn to the other current example preoccupying us, jus ad bellum, in relation to Israel and Gaza, the international law of whether force may be used is deeply uncertain. I'm stunned by the certainty with which young people put forth their views. They obviously know a lot more law than I do. The starting point is that the old pre-charter law of reprisals, just war, etc. are gone, and that everything is governed by the use of force provisions of the Charter. Article 2.4 is the key. I've mentioned that all members have to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, and Article 51, according to your view, either retains a parallel and inherent right of individual, perhaps collective self-defense, or provides an exception to the prohibition of the use of force in 2.4. And I have to say, and it's regrettable but true, that ambiguity and uncertainty remain at the heart of these provisions. Among the several issues which have not been judicially resolved with any clarity are the following. Is a single attack on a state required to trigger a proportionate right of self-defense? Necessity and proportionality remain within the present constraints of Article 51? Or can a series of perhaps quantitatively lesser attacks together trigger a state's right to self-defense? The International Court, in cases such as Iran oil platforms, avoided giving a clear answer, though it did suggest that a series of forcible acts could turn them into an armed attack, and there seems in the literature and practice growing support for this idea. How then to make an assessment of proportionality that is other than subjective? The use of force must be proportionate to the legitimate end sought. It can no longer be just punitive. Whether it can be directed to non-repetition of the initial armed attack as opposed to defense from it is also less than certain. And here we have to recall that Hamas's stated objective is to eliminate the state of Israel. So proportionality in response to that is very difficult to assess. Further, and of critical legal importance, is the fact that Articles 2.4 and 51 are essentially interstate. Neither Hamas nor the territory of Gaza constitute a state. Palestine is not yet a state, though its representatives are increasingly afforded standing to participate in UN events, including by the International Court in the Wall case and in the pending advisory opinion scheduled for the spring. So their common sense prevails. But the matter remains very complicated. Under the law of state responsibility, a state is legally responsible for the acts of individuals if it, the state, adopts such acts or if the individuals are in their service. But Palestine is probably not yet a state, and Hamas are not Palestine officials or acting on behalf of Palestine. In the legal consequences of the construction of a wall case in the International Court, the court held that Israel could not defend the legality of that wall that it was building on the West Bank, since it did not claim that the attacks it sought to prevent were imputable to another state. Three judges, Judge Bergenthal of the United States, Judge Coibens of the Netherlands, and I myself took a different line on that, though I held that the line of the wall was still illegal as it ran around not Israel proper, but the West Bank illegal settlements. But we must note that resolutions 1368 and 73 passed after the 9/11 attacks on the US by non-state actors indicate that the right to use force in the territory of another state in defence against attack by non-state actors was to be accepted. And a final question I want to mention to show you how unclear the law is whether self-defence is applicable in situations of occupation. Israel long ago withdrew from Gaza, but some may argue that the constraints it continues to apply there in effect constitutes occupation. And that argument is the more easily made in respect of the West Bank. Do those under occupation retain the right to seek liberation by the use of force? And like Hamas, are they liberated from the prohibition against targeting civilian targets? I myself think the answer to that question must be surely not, but perhaps Sir Adrian will have something to say. So I'm concluding with these words. I want to be clear that I'm not suggesting that the problems facing the international world order can never be ameliorated by improvements to the system and structures. At the end of World War II, the concept of human rights, which has come to play an enormous role, was in its very infancy. But 3 sons of Lviv, now under constant attack from Russia, catalysed concrete action. In 1945, Sir Herschel Lauterbach, who years later was to become the British judge at the International Court, developed the idea of individuals as subjects of international law, and that led in turn to the development of the idea of crimes against humanity and the basis on which Nazi leaders were held accountable at Nuremberg. And that in turn led on to the Declaration on Human Rights adopted by the Assembly without dissent. Raphael Lemkin, another son of Lviv, coined both the word and the idea of genocide, so ignorantly involved these days, both by governments and ordinary folk, and promoted the adoption of the Genocide Convention, which now reaches its 75th anniversary. And Louis Sohn, whose origins were also Lviv, assisted in drafting the UN Charter and the Statute of the Court. So I hope I've shown that the problems of today, so far as jus ad bellum are concerned, are really because of a lack of clear articulation of the very real legal problems that are out there relating to them, and particularly to the role of non-state actors. And I look forward very much to hearing what Sir Adrian and all of you have to say.
Thank you, Dame Rosalyn. Sir Adrian.
So the division of labour is that I'm going to look at the battlefield, a subject which is vast and complex, and which certainly for me brought to mind when I was thinking about this, that wonderful expression used by Owen Glendower in an exchange with Hotspur in Henry IV, Part 1, of the vasty deep, not quite unfathomable, but close thereto. As a consequence of the breadth of the bit that I have got, I'm not going to attempt a panoramic view, but instead I want to focus on a single event, which I consider to be critical in assessing whether the courts and the law have any utility when reflecting on what happens on the battlefield and how war is actually conducted. Back in late 2019, early 2020, when I was interviewing candidates as the successor to my successor as the British judge at the International Criminal Court, I was in conversation with a senior British official working in the field of foreign affairs who, out of the blue, expressed his personal antipathy at the interest that was being shown by the ICC's prosecutor into the role of coalition troops in Afghanistan. The view expressed was that the court surely had better things to be getting on with. I might have misinterpreted, but at the time the remark seemed to me to be tinged with a bit of outrage and a bit of anger. I think this is highly significant, and it is necessary, glancingly, to review the background to this, which in my view is highly significant, and what has happened thereafter. 3 critical things have happened. First, on the 20th of November 2017, the Office of the Prosecutor had asked the pre-trial chamber at the International Criminal Court for authorization of an investigation which would cover the Taliban, the United States forces, and other suggested unlawful acts in the context of the Rome Statute by members of other international forces, which would of course have included the United Kingdom. The request was refused by the pre-trial chamber on the 12th of April 2019, not, I immediately stress, because of admissibility or jurisdiction which were accepted, but solely because the current circumstances in Afghanistan then made the exercise untenable. The ICC's interest in what had happened ebbed and flowed over the next few years, but the refusal by the pre-trial chamber was the subject of an appeal to the appeals chamber, which was allowed on the 5th of March 2020. So that's the first thing. The second is that there were key legal challenges to events in Afghanistan by Lee Day solicitors in this country, namely 2 claims in the administrative court, Saifullah versus the Secretary of State for Defence and Norzai versus the Secretary of State for Defence. The claim in Saifullah is that the investigation into the deaths was not Article 2 compliant, and in Norzai that there was a failure to investigate the claim as well as a claim of a substantive Article 2 breach. Permission, critically, to apply for judicial review was granted in both cases in 2019 and 2020. Third, there were hard-hitting media investigations by the BBC's Panorama programme and by the Sunday Times. Now, I have no doubt but that those 3 events preeminently led Ben Wallace, the then Secretary of State for Defence, to set up what is my single event, which I want briefly to talk about tonight. And that is the independent statutory inquiry led by Lord Justice Haddon Cave into the circumstances of the deaths of various individuals at what is said to have been the hands of UK special forces between 2010 and 2013, the inquiry will additionally scrutinise 2 Royal Military Police investigations, codenamed Operation Northmoor and Operation Sestro, into these events and as to whether they were adequate. Lord Justice Haddon Cave set out the gravity of the investigation by describing the task as investigating alleged numerous extrajudicial killings during that period, which was purportedly followed by a decade-long cover-up and 2 investigations by the Royal Military Police, which are alleged not to have been fit for purpose. And in the meantime, the claims in Saifullah and Norzai have been stayed pending the outcome of the inquiry. Lord Justice Haddon Cave, interestingly, made an early visit to the ICC's prosecutor in The Hague, our very own Karim Khan, King's Counsel, and in his open ruling on restriction orders, he quoted from the ICC's December 2020 report into the situation in Iraq by the Office of the Prosecutor, in which it was observed, and Lord Justice Haddon Cave quoted this, that what happened in Iraq, open quotations, was the outcome of a more than 10-year-long domestic process involving the examination of thousands of allegations has resulted in not one single case being submitted for prosecution, a result that has deprived the victims of justice. So that is a conclusion by the International Criminal Court's prosecutor that has been cited by Lord Justice Haddon Cave early on in his investigation. He has also visited Australia, which notably released the Brereton report on the 19th of November 2020, reporting on war crimes committed by the Australian Defence Force during the war in Afghanistan between 2005 and 2016. The report found credible information and stressed that that was a conclusion that was not lightly reached concerning 39 murders of civilians and prisoners by or on the instruction of members of the Australian Special Forces, which were subsequently covered up by ADF personnel. The unlawful killings discussed by the report began in 2009, with most occurring in 2012 and 2013. Those are all being investigated by Australian prosecutors, with the possibility of there being prosecutions to follow. In this context, the principle of complementarity is key to the work of the International Criminal Court and to ensuring that nations are not the recipients of arrest warrants aimed at their armed forces to secure their delivery to the cells of the International Criminal Court. Put shortly, what is meant by complementarity is that if the relevant country does not deal adequately with the alleged offences, the risk is that the ICC will step in wherever it has jurisdiction. The hearings before Lord Justice Haddon Cave began in earnest on the 9th of October 2023, and I suspect that they will be unprecedented as regards the bright light that they will shine on all of the evidence that relates to what happened in the context I have just described. If you read the transcripts, the appetite for a full, thorough and no-holds-barred investigation is clear. Oliver Glasgow, lead counsel for the inquiry, is at least as fearless and uncompromising as Hugo Keith is in the COVID inquiry, and Lord Justice Haddon Cave is well known to be courageous, and he will follow the evidence wherever it takes him. So why am I reflecting on all of this? Well, ladies and gentlemen, my short point arising from these musings is that these recent events are simply unparalleled, and they signal what, in my view, is a very helpful development for the future in terms of being able to control, at least to an extent, what happens on the battlefield. I don't pretend that war crimes in war will suddenly cease, but I do think there will be an ever greater and far more meaningful role for the courts, for example, the ICC and our administrative court, along with its equivalent in other countries, and statutory inquiries such as Haddon Caves and Brereton in Australia, in bringing individuals to account in ways unthought of when Alexander the Great left Macedonia en route for Persepolis, Napoleon marched into Russia, or the Americans and their allies more recently went into Iraq and Afghanistan. It is the nature of human affairs that awful things will happen and the solutions for them will be imperfect, sometimes dramatically so. But I personally take great heart from the influence in the context of Afghanistan of the ICC and the British courts in ensuring that alleged battlefield wrongdoings can be and are the subject of proper investigation and inquiry. This, in my view, is a bright omen for the future, whatever the Afghan inquiry ultimately concludes, and whether or not the ICC, in the fullness of time, launches its own separate prosecutions.
Dame Rosalyn, is there anything that you would like to comment on what we've heard from that very optimistic approach taken by Sir Adrian?
And I've obviously found what Sir Adrian has to say very interesting. I mean, he has said that complementarity is critical, but it seems to me it's playing out in a way not expected. Perhaps he'll tell me if I've got it right. It was meant to be that if the local courts failed to do their stuff, then the ICC would step in. But from what he's told us, we have the ICC failing to do its stuff, and national courts and inquiries stepping in. This seems to me a sort of reverse complementarity, and all the better for that.
Adrian.
I won't come back on that. I think that will probably arise in the course of general discussion. What I am going to do is to put my toe in the water as well in relation to the position at the moment in relation to Gaza and Israel, simply in terms of jurisdiction, which is a question that is endlessly raised as to whether or not the ICC has jurisdiction, and only to answer it in this way. First of all, Karim Khan, the ICC's prosecutor, absolutely solidly believes that the court does have jurisdiction. And that is founded on the fact that, and sorry, excuse me if I go back just a moment, in November 2012, the United Nations General Assembly passed a resolution recognised Palestine as a non-member observer state. And adding to what Dame Rosalyn said, that so it is said, gives it the status needed for ICC jurisdiction. Now, not everyone agrees with that, but that is the position of the ICC. And I would just add that on the 1st of January 2015, Palestine issued a declaration accepting ICC jurisdiction over the occupied territories. It announced that it would join the Rome Statute, and in May 2018, Palestine, now an ICC member, requested an investigation into various conflicts. So that is the basis for the assertion that the ICC in fact does have jurisdictions in relation to what is happening in Gaza, notwithstanding the fact that Israel has not signed up to the Rome Statute.
We'll see if Yuriy Belousov can join us, and if so, I expect he'll appear on the screen behind me.
Now I'm here back.
Yeah,
Geoffrey.
Hello,
I was all the time here, don't worry about that.
just before I reintroduce him or introduce him a second time, it will be for all of you to decide what you take from the two addresses so far, each having different forms of optimism, one in the perhaps one in the outcome for all of us of greater certainty of the law once and when it is established, and the other of a particular form of optimism described by Sir Adrian. But let's see what, if the man with 110,000 possible cases of war crimes to investigate would like to tell us. Yuriy, can I limit you to about 5 minutes? Is that all right?
Sure, absolutely.
The floor is yours, sir.
But let me start rather than researching my previous life than the lawyer, but I will try to combine these two roles of my life. And I was focusing on the question you raised during our discussion regarding the way how to deter, committing international crimes in the future. And and especially it's a difficult question when you talk about one country which commits international crimes against another one. But, if we take states as human beings and we want to stop them from committing crimes, aren't we asking ourselves the same questions? We think how to prevent committing crimes from another person. And sure, traditionally, it goes to the severity of the punishment, which should deter people from committing crimes. And at the same time, we need to nurture, to educate, to socialize person which shouldn't commit crime in the future. And I think it fully works with states. That's for many years, international society tried to educate, to nurture, to socialize Russia in a normal context, to have any business with this country and to reduce the risk of any bad things committing from this country. But the problem is if the just severity of the punishment doesn't work, if we talk about the inevitability of the punishment. And that's, from my perspective, it's exactly what happened with the Russian-Ukrainian context, because we all know that the war started in Ukraine a long time ago. The Russia attacked Ukraine in 2014, not 2022. And before that, Russia attacked Chechnya, then Georgia, then Syria. And the world was making or pretending, let's say, that they don't see what Russia is doing. And that's exactly gave them the feeling that there is no punishment for such an actions. Again, if we see, let's come back to analogy with human beings. Sorry for simplifying for serious, participants of this event. Maybe it's obvious, but but if we see the person beating another one and people around pretend they don't see that, the person starts to beat another person. No one reacts, and it beats third person. No one reacts again. what it tells this person, that society takes this behavior as normal first, or society is too weak because the offender is a very powerful guy. Maybe he had a knife, or maybe he had some other weapon. That's why it's better to see that at least if he doesn't touch me, if it's okay, it would be okay if he touched other persons. And I think that's exactly what was happening before 2022. Why 2022? Because in 2022, these subjects started to commit such a serious crime that it was difficult not to see it, even for international community. Bucha maybe was the first example, and then Izium and some other, Kherson and other places, when the international society understood that we need to do something with these people, with this country, let's say. And I should say that first, it was extremely important that the democratic world raised the voice. Such behavior for the country is not okay. And I really believe that at the moment, so there is almost not no country in the democratic world which supports Russia. And that was first. Second, sure, it was the issue of inevitability of the punishment. And that's where international society faced a pretty big challenge. At the moment, we have, as you mentioned, this number of crimes, but looks like the victim has much more investigations against the offender than neighbors. And that's also interesting. I'm here as a researcher now, trying to assess the situation objectively. So we have, at the moment, we have already identified 456 suspects. So suspects in Ukraine legislation means that the person who was officially notified about the committing of crimes, like preliminary charge, let's say. So we have 456 for war crimes, 293 already in our indictments in our courts, and we have 66 verdicts of national courts. I don't mean the crime of aggression. Crime of aggression is a bit separate figures. What about the rest? Fortunately, as you know, ICC started this investigation, and we have first orders for arrest, and that's already good. 24 other countries started their own investigations against the war crimes committed in Ukrainian context. But at the moment, so definitely it's a good start. But at the moment, looks like more efficient instruments are sanctions, which like a kind of financial, punishment, which may be, from my perspective, at the moment, when we talk about international conflicts, may be at the moment most effective tool. The problem is now that the world up to now is not sure what to do with the biggest crime of aggression. And that's also interesting. So we see two countries fighting with each other. So we see definitely aggressor who attacked one of the countries, unprovoked aggression without any justification. And the world is still too shy to call it aggression. Because it's maybe it's aggression, but how to prosecute for this? And it's interesting dilemma, because a lot of countries do not want to have a precedent. And that's the biggest problem, because everyone thinks, okay, if we would punish Russia, we call this crime, Russia commits aggression. If we have a precedent, maybe someone would look what we did a long time ago, and we would be prosecuted for improper behavior in the past. And it's also interesting. And the aggressor thinks that no, there is no reaction. No one calls me aggressor. They're still thinking whether to have special tribunal. Even if there be special tribunal, it shouldn't prosecute the acting president. For Ukraine, it's really discussion is just really interesting, because I'm interested, maybe it's not a proper word, but when there's a discussion about the tribunal for aggressor, but the president shouldn't be on the bench. What kind of signal it gives to other hooligans in the world who are watching the situation? They just staying and watching this conflict. And they think, why should we? This guy attacked the country. They have taken 1/3 of this country, the territory. They're killing people there. And there is a huge chance that the guy wouldn't be punished for crime of aggression. Why won't we just capture just small part of the territory of our neighbor? Maybe we will not kill anyone. We just capture territory, or whatever. We all know what aggression means. So many different forms of the aggression. And inevitability of the punishment for international crime globally, from my perspective at the moment, is the biggest problem which will not prevent such cases in the future.
Yuriy,
How this punishment should look like is another issue with for researchers and scientists worldwide. Sorry, I hope I didn't manage to be in 5 minutes.
No, don't worry, Yuriy. I'm going to draw your contribution to a conclusion for the moment, simply to ensure that students and others get a chance to ask some questions and make some contributions. But I think I would take from what you've told us already that you will probably find support in what Adrian said about the involvement of countries as well as the ICC in the pursuit of remedy. I wonder if Dame Rosalyn has anything to ask you or anything to comment on his hopes for crime of aggression, for example.
No, I'm simply aware of all of the problems associated with that, and it's just an extra hurdle to be dealt with.
And one contribution from me, and then we'll have some questions. But please stay on the line, Yuriy. Many thanks for making yourself available to us today. It's very good of you. There may be examples, we may have time to review one or two of them, where the slow speed of response, either of the justice system or of the world order in the form of military intervention, leads to ever greater consequences. The Crimea example is the most famous one for the time being, but there are others, and possibly even involving the Israel-Gaza conflict. But stay on the line. And so students in the room with 30 seconds, hands up, who'd like to contribute? Yes. Microphone coming. Yep. 30 seconds.
My question is about deterrence, and it's mainly focused on Adrian's point about battlefield conduct. So lots of sort of sociological studies about criminal behavior suggest that it's not the fear of punishment that deters, that alters behavior, it's the fear of being caught. So given that video gathering technology is so widely available now, I'm just wondering whether the sort of proliferation of videos means that it'll be easier to prosecute individuals for perpetrating war crimes.
Very much. Next one.
What can the role of the courts be in facilitating the end of current conflicts rather than merely accountability once they have ended?
I couldn't hear that terribly well, but you could hear that, could you?
Yes, but I don't understand it.
My question is hypothetical, but if Russia were to achieve a breakthrough that resulted in strategic success...
You'll have to speak up a bit, partly because I've got dodgy ears, partly because the microphone isn't loud enough.
No problem. My question is hypothetical, but if Russia were to achieve a breakthrough that created strategic success and compelled Ukraine to agree to an end of the conflict that wasn't on their terms, whilst the law remained the same, would its application be any different?
So, Adrian.
Well, I'm going to take videos. I put a line through, because we only had 10 minutes, I put a line through the section that I wrote on this. In one sense, I agree. In one sense, I don't. Obviously, in relation to detecting crime, video evidence has been unbelievably useful and has completely changed the landscape, including, and this I think gets closest to your point, body-worn cameras worn by police officers. The problem with this is certainly there's no indication at the moment that we're going to have soldiers going into battle with body-worn cameras attached to their uniforms, running throughout whatever it is that they do. And in particular, in the context of what happened in Afghanistan, the idea that there would be, that we're going to have the benefit of what is alleged to have occurred, to have had the benefit of video footage, is very remote. So yes, some assistance, but... That, I agree. Yeah.
I'll pick up the query about whether ongoing conflicts can be stopped by courts, and I can only speak about civil courts and in particular the International Court, and I'm deeply sceptical. The International Court has dealt with the problems in Ossetia. They've dealt with conflict between Congo and its neighbour. They've dealt with a variety of ongoing conflict issues. It's not that the International Court refuses to take them on, but the compliance rate, which generally with the court is extremely high, because states who have a judgment against it know that one of these days they're going to want to come as an applicant at the court. Nonetheless, in those sorts of circumstances, there's finessing of the outcome.
I'll take 2 or 3 more students, 30 seconds if any people got their hands up. 1, 2, yes. One here.
Hi, mine's about one way or another these conflicts are going to come to an end, and when they do, one will be a victor. And what threat does victory pose to the enforcement and fairness when it comes to international war and crime prosecutions?
Thank you. The next one back.
Well, I probably ought to take that.
Yes.
I mean, I think it's one of the long-standing criticisms of the whole sort of panorama of international criminal justice that it too often has the appearance of victor's justice. I think all of those who work in the field, be they judges or prosecutors, are keenly aware of this, and the ICC has fought hard to focus on prosecutions that aren't simply the victors bringing people they can't be bothered to prosecute themselves before the court. They've had some success in that, but it is a problem. When I was first appointed as a judge at the ICC, one of my early questions to the Foreign Office is when they were going to set up an international snatch force that were going to go in and get those on both sides who had allegedly perpetrated outrages. I was told in very diplomatic terms that I was never to mention the idea again.
Hello, hi. My question is, does the principle of complementarity mean that the ICC should be taking greater efforts to cooperate closely with states in which investigations are taking place with a view towards dividing up the workload, for want of a better term?
Yes, I mean, as I've hinted already, really see complementarity as being one of the really interesting ways forward, I think, in terms of the development of international criminal justice. I strongly believe that there needs to be greater cooperation between member states and the ICC, and I think there needs to be a much greater shouldering of responsibility for launching prosecutions in nation states rather than relying on the ICC, which after all has got how many courtrooms for hearings? It's either 2 or 3, I forget now. So there's an absolute limit to what the court can do. And so I think this requires a far greater degree of engagement. I think there was an understandable feeling in Rome back in the day that having brought the ICC into existence, the rest of the world could just let it get on with its job, and that it wasn't really going to be the responsibility of individual states. And that is so wrong, in my opinion.
Nothing to add, I agree.
Nothing to add. Right. Open generally to questions, same protocol. Who would like to ask? First of all in the hall, and then I've got things online.
Hello. A question for Mr. Belousov, if he's still online. He mentioned that sanctions were the most effective form of accountability in his view. Why does he say that, and did the panel have any other views on sanctions as well?
Okay, thank you for your question. So, let me consider aggression as a subject for our investigation, and we consider different forms of aggression. So we consider military aggression, that military invasion. We consider political aggression, which umbrella for all other types. We consider informational aggression when we talk about the propaganda. But we also talk about the economical bloc of Russian Federation, which funds, supports the army before invasion, transfer the army to our boards, and funds them. And sanctions help to say to the companies which support aggressor that such behavior is not okay, and block of any financial channels, block accounts in the banks really work. A lot of companies left Russia because they didn't want to be under the sanctions. They didn't want to be considered as the ones who sponsor aggression in any form, and they left Russia. And it goes very fast. From my perspective, sanctions, I don't mean the sanctions should substitute the criminal investigation and punishment. Sure not. There is always actually risk. The sanctions is a fast instrument could compensate or even substitute. And there are a lot of risks for right to property and other rights which could be potentially violated by such approach. But sanctions in line with criminal investigations work much more effective than the investigation itself. And maybe one last point regarding the previous question, regarding the cooperation of the state and ICC. I could say, I haven't worked in other countries, but I could say that we have a perfect cooperation with ICC in Ukraine. ICC has an office in Ukraine, and we on daily basis work with the ICC guys, sharing our evidences, what we have. It definitely increased the efficiency of both sides.
Thank you. Anything to add to that?
No, sanctions clearly sometimes do work, and we've seen it in regard to many undesirable international situations, including apartheid as it was in South Africa. We shouldn't underestimate the role of sanctions.
Sorry, I pressed the wrong button. So, online, from Joseph Perry, short of limiting Putin's freedom of movement, what real impacts are there likely to be on Putin, assuming he doesn't ever face trial at the ICC?
Adrian can answer that better than I can.
What will deter Mr. Putin? Well, I would have thought nothing. I've been told I mustn't cross my hands because of the microphone. Nothing short of some form of defeat. I think it is very difficult to see how else the international community can intervene, given that sanctions have now been ratcheted up probably about as far as anyone is prepared to go. So I'm afraid, although I'm optimistic about many aspects of this, I'm not very optimistic about Vladimir Putin ever seeing the inside of a court of law which is investigating what he is alleged to have done over the last so many years.
I'd like to ask a question, but I'll get somebody else to ask one. Yes. Oh, sorry, over here. Yes, of course, I'm sorry. Master Howe.
Fancy forgetting me. I've got two questions, but I expect you're only going to allow me to ask one. But can I ask Mr. Belousov this? Going back to video evidence, I'd be interested to know to what extent you are using video evidence, particularly from cell phone footage, in your prosecutions, because I would suspect that there would be a challenge in establishing their provenance. So I'd be interested in hearing about that.
Thank you so much for your question. It's extremely important source of evidence. We are in a situation when we don't have a physical access to a lot of crime scenes. That's the biggest problem. We are talking about Mariupol, we are talking about Donetsk, Lugansk area, and some other occupied Kherson area. And we got information about the crimes being committed. we had to change our approach to investigation. We have to start to launch new approaches. And OSINT is the most famous approach, what we do to get the information about the events when you don't have a physical evidence. That's why lots of videos, not just from the territories we don't have access to, but even when we have access, we found a lot of video materials from camera surveillance, from mobile phones and other places. Sure, in order to prove origin of this video, we need to assign a special expertise according to Ukrainian legislation. I can't just put this video as an evidence and use it in a court. I need to have expert conclusion that this video is original, wasn't interrupted, there was no any other bad things which influence the quality of the video. But I could tell you that the video is definitely one of the biggest source of information. In addition, we have a lot of our witnesses and victims who left Ukraine. We have around 8 million Ukrainians left to Western Europe. Some of them came back, some still there. In some times, they decided to say about that they became a victim or witness of the crime. We fortunately have an opportunity to provide them a resource. They can download video, they could describe the event, being staying in Europe. And using this video, using some other sources, it's much now using different technologies. It's much more easier for us to identify a suspect. Much more easier. I could say that a lot of our suspects been identified having video or photo of these people. That's why it's extremely important source of information. And that's actually now when they been kicked off from some territories, they're trying to delete everything they had on the territory. All documents, all videos, on servers, on surveillance, they tried to delete it. In Kyiv region, when they were leaving the Kyiv area, they left a lot of videos, and they're learning from the mistake they did in this war. But again, video still is used in open source video, which is extremely important and helpful.
Question at the back. Probably just a few more questions and then we'll close. But that's not the end of your opportunity to speak to the speakers, as you'll discover. Yes.
Hi, sorry, I have another question for Mr. Belousov. Are the Ukrainian people going to accept and be happy about the prospect of peace, or are they going to sue for something else?
Oh, it's a good question. To understand it, so we should take into account the hundreds and hundreds of years of our neighboring with Russia. And it's not about this conflict which just appeared out of sudden in 2014, or it's for hundreds of years Russia tried to capture Ukraine, to erase our identity and other things. That's why for us the peace itself, it doesn't make any sense. We understand that if we will not solve this problem now, we would make a gift to our children and grandchildren. I don't want my son to continue the work I should finish. That's why for Ukrainians, again, so peace without the victory means nothing, honestly. For a lot of Ukrainians, I can't say for everyone, but what I feel, what I know, that's the answer.
Before I take two more questions from the hall or online, I'd like to ask our two speakers a question arising from the unstated but general fear of those in the field that all international courts are in fact subject to some forms of political pressure, subliminally or otherwise, and that one of the things that sometimes is thought to do is to slow the process down. I have in mind Dame Rosalyn's observations about the lack of clarity of the law. Might it be better if the law was clarified more quickly? But a question for both of you arises from a couple of experiences concerning Israel. In 2010, there was a flotilla that was attacked. Efforts were taken to get it to the ICC. They were delayed and delayed and delayed. And if the ICC had taken the case, might that have stopped the next conflict, which was called Operation Protective Edge, which happened in 2014? In 2014, the political leader of Hamas, Ismail Haniyeh, agreed that he would like the ICC to be involved, and the following year they obtained or they offered jurisdiction. But it took the ICC how many years? 5? To decide that it had jurisdiction. In each of these cases, might swifter justice have had an effect of slowing or stopping the next stage?
Geoffrey, I think you've actually dealt with two things at the same time. One is the spectre of political interference getting in the way. The second is the sad fact that international justice is very often slow justice. In relation to political pressure, I would certainly, on the basis of my own experience, robustly fight back in relation to that suggestion. Certainly, the International Criminal Court has taken into account political realities, and that's exactly what it did originally with Afghanistan, in that the political reality was an investigation was not going to be possible. That wasn't giving in to political pressure, that was accepting political realities. But in relation to delayed justice, I think that is one area where nearly all international tribunals and the ICC have to an extent come a cropper because it just takes too long.
Well, it's very hard to disagree with that. I mean, I think courts are not always timid. The International Court of Justice has dealt with some very sensitive issues, including conflicts between Serbia and Montenegro on the one hand, and the other component parts of the former Yugoslavia on the other. It's had its head well above the parapet. I will confess I am deeply sceptical of the idea that all would have been well if the offer of jurisdiction over Hamas had been accepted at an early stage. But speeding things up is firstly difficult for the ICJ. It operates on a shoestring. It has now an extremely heavy docket and not the resources that it needs to cope with that. And secondly, there's always the question of what the priorities should be. And we're in a phase where every country now, every applicant or respondent now wants provisional measures, a form of interim blockage meant to preserve the outcome of what could be decided on the merits. And that is a huge slowing down of the process.
Last question from the room. Sorry, only one, but I'll explain. You'll get a chance later. Yes.
Hi, I had a question for Mr. Belousov.
We'll come back. Was your question for Mr. Belousov? No. I'm going to take the other question first, and then we'll see what we can do about Mr. Belousov.
How can accountability be adapted to overcome obstacles such as the Soviet idea, which seems to be inherited by Russia, that there is a Western international law and the Soviet international law, which is the latter of which is applicable to Russia and the post-Soviet space?
One of my early books was on this subject, and all one can do is put out the ideas about it. It's very intermittent, this. I mean, in the era of peaceful coexistence, that was the idea being advanced. And then we went through years where there was a significant alignment with the Third World, and regular international law was convenient for all concerned. They had the ability to participate and develop. And I don't think so much. It's now said that the law is different. It's just the reading of the facts is put in a way that leaves one open-mouthed.
Nothing to it.
So, a few things from me before the Treasurer. Choreography. I'm afraid our speakers aren't yet free. They will be ushered out of this room, tethered to a table to which a drink will be taken, and you're then able to speak to them, and they're not going to get swamped by other grandees for a few minutes before we leave you. So you get a chance to speak to the speakers afterwards. I don't know, and there's nobody from the technical department now in the room, whether it's possible for Mr. Belousov to stay online and for people to stay in the room who want to ask him questions. If that's possible, we can do it. But the rest of you will have to shift very rapidly to get outside to the reception where drinks will be waiting for you. You've heard a whole range of really valuable contributions and questions today, but I'm not sure that any of them is really a clear answer, nor I'm sure that a clear answer can be coming your way. Remember this, as particularly the students review the post-1945 creations, the United Nations and the other bodies, and the documents that went with it. They were created by people who had first-hand experience of either one or usually two world wars. They knew better than our present politicians in the Northern European countries do what man can do to man, and they're worth considering very carefully. And why we should all be worried about this is perhaps reflected in Article 1, not of one of the United Nations documents that deals specifically with war. It's UNESCO, education, culture, science. And Article 1 says something like this: since it is in the minds of men that wars start, it is to the minds of men, men means men and women, it is to the minds of men that we must turn to make the peace. The first minds of men are the warmongers. The second minds of men are, I think, us. For responsibility to stop war cannot be subcontracted to judges. It ultimately is going to lie with all of us. Treasurer.
Well, thank you very much. Geoffrey, do you want me? Oh. Thank you very much indeed for those closing remarks, which makes my job much easier, which is to profess our profound thanks to our speakers in the room and Mr. Belousov in Kiev for very thought-provoking, if unclear, answers to the questions that have been put. None, I fear, have provided a recipe for actually producing peace, but all of them, I think, have in different ways shown that accountability is at least a possibility which should pass through the minds of people thinking of doing terrible things, and some of that may be prevented. But that's my only not very profound thought, but I don't think we could have assembled a more appropriate or distinguished panel before us tonight. So thank you all very much indeed. And just one final word of thanks. One final word of thanks for our chair, Master Nice. And if I can just steal his own word, I can think of no more top person to organise this event, or indeed all the others he has organised. And I'd like to register our thanks to him as well.
Yeah.